Hello, I'm Glenn Wright, President and CEO of PDA, and I am extremely excited to be here at PDA Week, and even more excited to be here with David Jaworski. He's a man who wears many hats. He's PDA staff. He consults for some of the largest pharmaceutical industry. He just does everything, and we're here to talk a little bit about something that could be very important for industry. So I've got 3 questions for David, and welcome, David.
Thank you. Appreciate it.
It's
great to be here.
Great to have you here.
Yeah.
And so these 3 questions are, I'll just give you the first one. So the industry's been hearing about a new challenge being made at the U.S. Supreme Court, and this is to the Chevron USA versus Natural Resource Defense Council, Inc., that could have a significant impact on our industry. What is this Chevron versus NRDC decision, and how has it been foundational on how federal agencies, including the FDA, set rules?
Okay, well, so it started off as the EPA was given responsibility to enforce the Clean Air Act. And when they did the Clean Air Act, there was a lot of ambiguity in the law that was passed that the EPA had to set regulations. Well, so what it was challenged, so what happened is, so EPA set one set of regulations, and then a few years later, they changed the regulation, and the NRDC sued the government and actually won its case, saying you had to go back to the original interpretation of the law. And then, so what happened is Chevron then countersued, and it went all the way up to the Supreme Court. And basically, they said that it's the responsibility of Congress to interpret the law and the judges to interpret it. And so they came to, and the government was saying, no, it's up to the executive branch to enforce the law, therefore we could interpret it and set the regulations. So it really supported, regulations started earlier, but so regulations even at the FDA are impacted by this because this whole challenge in Congress is all about how do we establish what is the law? And if you think about the law, when you're looking at it, lots of times Congress doesn't interpret, doesn't say exactly what's going to happen with their law or how to enforce it. So when you're looking at this case and how it's important, so what happened is the Supreme Court in Chevron versus NRDC ruled that there was a 2-step process. So basically, the judges in all the courts around the United States are supposed to look at and say, what is, did the law actually state what it should be interpreted as in regulations? So like if you look at it from a standpoint of like looking at cars, it's very simple to think of automobiles, but there's a lot of regulations about how a car is actually put together. Like it has to have tail lights. It has, and there was a ruling change on the tail lights where they had to put the big one up top.
Yep.
Because there was too many accidents. Well, those are all regulations. And when you look at it from a drug side, you also have the same impact because Congress doesn't know everything. So they leave it up to the FDA to interpret regulations. And it's almost like looking at drugs. And if you have the interpretation of a drug, say an NDA and a generic drug, so what the case is all about is essentially the same thing as saying FDA changes the definition of an NDA and an ANDA, and they combine it into one and say, you're going to follow the regulations of the ANDA. Think about that. You're not going to follow the NDA regulations. You're going to follow this. And you think about all the court challenges. So what the court said, there's 2-step process. You interpret the law and see if it's actually stated in the law where that's what the interpretation of Congress is. If it can't be done and the judge has to exhaust all its possibilities of looking at that, then it's up to the agency to come up with a regulation and interpret the law.
Got it. I think I got this. So basically we have, Congress setting laws, so they're establishing the laws, but a lot of times there's not all that detail in the law.
Right.
And so we've got the agencies coming in saying, we're going to provide that interpretation, that detail.
Right.
And so that's really what this decision back in the 1980s really clarified, was how that could be done.
Right.
Gotcha. Okay. Really interesting. So, we've got this new case that's being heard. So, what are some of the arguments and resulting justices' comments that are being made in the case that's now being heard at the U.S. Supreme Court? In this case, is the Lopper Bright Enterprise versus Raimondo that challenges Chevron versus NRDC. So, what are we hearing?
Oh, it was very interesting. They actually had the hearing at the Supreme Court a couple of weeks ago, and what they said is interesting because you have two of the justices, you have uh, Kavanaugh and you have Barrett, who actually supported cases that they said Chevron applied, which is really interesting. And there they are now at the Supreme Court, and they're having to make this decision. So when they looked at it, they said, so you have the conservative judges saying, well, now that Chevron has really usurped the rule, and it's really up to Congress to make the law, and it's up to the judges to interpret the regulations, not the executive branch. Then you have on your side the liberal justices that were pretty much in support of Chevron doctrine being applied, the Chevron deference, where they actually said, well, we have all these cases that were thousands of cases were actually looked at, and they used the Chevron deference in their decisions. All these lower courts, all these decisions about regulations. So it's thousands of them. And they say, well, basically, we have to keep this in place because it gives a nice set of rules about how to interpret when the legislation is weak and it doesn't have the exact interpretation of what could happen or could change over time. And they say that's a nice flexible process, but it puts constraints on the judges to control that. Well, some of the conservative judges, you got the Chief Justice Roberts, he's coming in sort of like in the middle saying, well, maybe it needs to be tightened up. Maybe it doesn't need to be as loose as as some of the plaintiffs were stating in the case. So there was a lot of back and forth about, okay, should Congress have the responsibility? Should the executive branch? Should the judges really make the decisions and everything? And it was really this back and forth that led people to believe there's going to be some changes in that
Wow.
from their interpretation.
So I mean, so they do change it, right? So things do change. I think it sounds like it could be a full reversal. It could be tightening it up and partial reversal. So what are some of the potential outcomes then? What could come out of this case? Could be nothing. They could say, hey, we're sticking with it, right? So what are some of the potentials?
Well, the easiest thing is if they support the Chevron deference and they say that's going to be the law of the land, because everything stays the same basically with all the regulations, and at the FDA, so you got all of the Code of Federal Regulations. There's a huge volume of CFR
Absolutely.
regulations, and then there's the ones for the Public Health Service Act. There's for the Drug and Food and Cosmetics. All of these regulations, there's tons of them. They stay in force. Now, if they modify and tighten up the decision so that they put restrictions on the judges, what'll happen in that case is current law regulations will stay in place. Nothing will change. But new cases going forward are going to have that ability to they'll be able to challenge
in court, they'll be able to challenge what that new proposed rule is.
Yes, easier than in the past, because in many cases before, the judges will say to the agency, like the FDA, well, what do you think? Because we're relying
on you, the experts. Yeah. We're relying on you, the experts, to kind of set this rule.
Yeah, because you think about it, the judges, when in their original decision, they said that the Supreme Court said, we don't have the knowledge, the scientific or the technical. Think about with the cars. We didn't know if that light above on the back of your car is really needed.
Yeah.
And that's going to be a technical decision, or a scientific in the case of the FDA. Well, we can't understand all this drugs, and we don't know what a gene therapy is and all this stuff. That's all new. So therefore, we're deferring to you. So, but it'll make it easier for courts if there's a tightening of it, so to challenge those things.
Right. So the industry can come back, industry member can come back and say, we don't agree with this rule. We're going to provide our scientific viewpoint. You, the judge, must now decide
right.
which way this is going. Right. And
So,
so that'll
yeah.
be significant.
And then it'll be up to court. There'll be more cases going to the court, but they think there'll be less than if they actually eliminated it. And
so now what happens? I mean, so we've talked about the doesn't change, no change. We talked about the middle. What happens if it gets overturned?
If it gets overturned and they say that the Chevron doctrine is moot, that the deference is moot now, what will happen is you're going to see regulations can all be challenged. They can challenge
Wow.
CGMP regulations.
Holy cow.
They can say that we don't agree with this. They'll want to take it to court, and they'll try to make an argument to go to court. Or the other thing is, a judge may rule that the law wasn't set right, and it goes back to Congress, and Congress has to redo the law.
They have to clarify it in
They
the
have
law.
to clarify it.
Wow.
So it could
big
be
changes.
passed back.
And FDA is only one. This would affect all agencies and all agency
Affects
rules.
everything,
Yeah.
all agencies. And
Wow.
And from a drug perspective, it's a little bit scary when you think
A
about
little bit, yeah.
all the regulations. Like perfect cases right now, the FDA is trying to define on the biologic side all this stuff with gene therapy, and there's these bad actors out there that are making gene drugs or making modifications to cells, and they're injecting them into patients, saying it's a doctor's prerogative, and the FDA is trying to say no, you can't. Or like on the medical device side, they're trying to the FDA is trying to regulate a lot of these tests that are being done now, and that what's going to happen is it's going to be all that's going to be wide open.
Wild West.
Yeah, where
Wild
people are
West.
going to say and so look at some judge, they may go to Texas or they may go to some place where it's favorable for deregulation and try and get these things overturned.
Gotcha.
Over time.
What a great topic, and it's happening this week at PDA Week. Really excited to have you present. And again, if you're not here at PDA Week, you're definitely missing out. And so make sure you make plans next year. But this is going to happen on Wednesday morning.
Yeah.
Extremely excited about it. Again, great content for PDA, and I really appreciate you doing the presentation. So look forward to it.
Great. Thanks for having me.